Good morning. My name is Jacqueline Smith, and I'm elected as the Clerk of the Circuit Court for Prince William, Manassas, and Manassas Park. I'd like to welcome you and thank you for serving as potential jurors this morning. The purpose of this video is to outline the jury process and the variety of roles in the courtroom. We'll also cover what to expect and some rules and methods to follow when making your decision. You've been called here to serve as a prospective juror. Selection of jurors is established by the statutes of the Commonwealth of Virginia. Being a juror is one of the most important responsibilities in the justice system, and a trial by jury is a right guaranteed to all of us by the Constitution of the United States and the Constitution of the Commonwealth of Virginia. As stewards of the Constitution, citizens help maintain the rights provided therein. A jury trial cannot be held unless people like you are willing to uphold that civic duty. Before I was elected as Clerk of the Circuit Court, I was an attorney who tried cases before jurors like yourselves right here in this court. And I can honestly tell you that in many cases, trial by jury was my client's only path to justice. Every litigant who comes into court has a right to trial by jury composed of their peers who are duty-bound to render a fair and impartial verdict. That verdict must be based upon the evidence presented at trial and the law about which the trial court instructs. In the next few minutes, you'll learn more about the important duties of a juror. I ask that you listen carefully and take your responsibilities seriously. Your service as a juror is vital to our justice system and ensures that all Virginians and citizens of Prince William, Manassas, and Manassas Park are accorded the constitutional right to a trial by jury. The court and the parties to litigation realize jury service may disrupt your daily routine and cause you some inconvenience. If you have a physical ailment, special conflict, or genuine hardship, please bring this to the court's attention. In some cases, the court may excuse you or defer your service to a later date. You will not be asked to serve more than one term every 3 years. Having a busy schedule is not considered a reasonable excuse. All jurors have the right to time off work, as stated by Virginia law. Most workplaces supplement pay during absences for jury service. The court provides all selected jurors a financial stipend for the duration of their service. Please note pertinent information located on the back of your juror summons for general instructions, including excusal, attire, parking, and miscellaneous questions. We understand it's difficult to take time away from work, but we want you to understand that by law, you can't be fired or required by your employer to use sick leave or vacation time to make up for the time missed from work for your jury service. Simply notify your employer of your call to serve. If you need a work certificate to provide to your employer, please request one when you report for jury service. In deciding how to dress for court, keep in mind the formality of court proceedings. Clothing that is distracting or offensive or overly casual is not appropriate. When you sign in for jury duty, you will be given a badge to wear at all times when on court premises. This lets everyone in the court know you are an active juror and to behave accordingly. Even before being selected to sit on a jury, please remain in the jury room or appointed area, as you may be called upon at any time. The jury coordinator must know where to find you at all times during your service. There are two types of cases in which you may be asked to serve: a civil case and a criminal case. In a criminal case, in which the defendant faces a misdemeanor charge, 7 jurors will be selected to hear the case. A person convicted of a misdemeanor may be fined or sentenced up to 12 months of confinement. 12 jurors will be selected for a criminal case when the defendant is charged with a felony. A person convicted of a felony offense may be sentenced to pay a fine or to serve jail or prison time exceeding 1 year. The number of jurors needed in a civil case generally depends on the amount of damages claimed by the plaintiff. Generally, 5 or 7 jurors will be selected to serve. When it's time for a jury to be selected, the bailiff will escort all potential jurors from the jury room into the courtroom. Let's take a moment now and introduce you to the people who will be working in the courtroom. The judge presides over every trial. The judge will conduct the case, decide what evidence is allowed, instruct the jury about the law,
Familiarize.
and hear and decide the legal arguments made by the attorney.
Please be seated.
In a criminal case, the prosecuting attorney, who represents the Commonwealth of Virginia, brings the case to trial. In a civil case, a plaintiff, with or without the assistance of counsel, brings the case to court. The defendant in a civil case is the person being sued. In a criminal case, the person charged with a crime is also known as the defendant. The defendant's counsel is also called defense counsel. The Clerk of Circuit Court creates and maintains the official court record. They also assemble and swear in the jury and witnesses and oversee the management of evidence. Sometimes a court reporter will record every word spoken during the trial. The bailiff or sheriff's deputy is in the courtroom to keep order, maintain security, and to help the judge or jury as needed. Before the trial begins, a group of potential jurors will be questioned and selected. The clerk will ask the potential jurors to stand, raise their right hand, and swear or affirm that they will truthfully answer the questions they are about to be asked. The judge will state the names of the parties, their attorneys, the witnesses involved in the case, and a brief description of the nature of the case. In the interest of providing a fair trial, it's extremely important for you, the potential juror, to acknowledge if you know any of the persons identified, or if you have any other conflict that will keep you from being fair to both parties in the case. For an impartial trial to occur, it's important that jurors provide honest information during questioning. Not everyone will be selected to be on the jury. The questioning of the jury panel is called voir dire. Voir dire is a method to determine whether a prospective juror can be impartial and is otherwise qualified to serve on a jury. During this questioning process, you may be asked about your occupation, as well as other questions you might consider personal. Usually, questions are asked of the entire panel. At times, an individual may be asked to explain his or her answer. If your answer is embarrassing or too personal to share with everyone else, you can request to speak privately to the attorneys and the judge to explain your response. By questioning the jury panel, attorneys are able to narrow down the pool of jurors to people they think will deliver a fair verdict in the case. There is no limit to the number of prospective jurors the attorneys may ask the court to strike for cause. The request will usually be made on the grounds that the juror cannot be impartial due to their life experiences, because they know a party in the case, or for some other reason considered sufficient by the judge. Remember, Virginia Code 8.01-353 allows attorneys to do proper research of all jurors. A preemptory strike means that the attorney does not have to state a reason to excuse a potential juror. There is, however, a fixed number of preemptory strikes each side is allowed. It could be simply a hunch or a feeling that causes the attorney to believe a particular person may not act favorably to his or her client. But an attorney may not use a preemptory strike to exclude a juror based on race or gender.
The attorneys kept looking up at us and writing on their papers, and it felt like I was being graded on the answers that I had, and it felt a little uncomfortable, but I just kept wondering if I would get chosen or get to go home.
You may be excused at this stage of the trial. Do not take your dismissal personally, as there are many reasons a person is not selected to sit in a particular case. You have already performed a valuable service by just being present and participating in the selection process. Once the jury has been selected, the trial will begin, and the attorneys will present their opening statements. An opening statement is an overview of the case the lawyer intends to prove and is not to be considered as evidence.
Your Honor, I would like to show the defendant a photograph that was taken of the vehicles that day.
After opening statements, each side will have the opportunity to provide evidence to support its case. Evidence may consist of witness testimony, documents, articles, photographs, weapons, or just about anything pertaining to the case. The judge may permit you to take notes during the trial. If you are allowed to do so, make sure your note-taking does not distract you from following the trial. The notes will be collected at the end of each day and at the end of the trial. The notes can be used to refresh your memory later, but you should not share your notes with other jurors or anyone else. Once a lawyer has finished the direct questioning of a witness, the opposing lawyer will have the opportunity to cross-examine that witness. After the plaintiff in a civil case, or the prosecutor in a criminal case, is finished presenting their evidence, that party will tell the judge that it rests its case. The defense is then given an opportunity, but is not required, to present their evidence.
Objection, Judge.
Trials are conducted according to the rules of court and law, and objections are made to ensure the rules are followed. Occasionally, you may hear a lawyer object to a certain question asked of a witness or to certain evidence that is presented. If the judge concludes the question should be allowed, the judge will overrule the objection and the witness will be allowed to answer the question. However, if the judge agrees with the objection, that objection will be sustained, which means the jury will not be permitted to hear the answer to the question. From time to time during a trial, the attorneys may request a bench conference so they can discuss with the judge various legal issues, such as whether certain evidence may be admitted. The jury may even be asked to leave the courtroom for a period of time so that the judge may discuss the matter in private with counsel. This may be frustrating to you, but it's important that you, the juror, only hear the evidence that the law allows to be presented in a case. Remember, whenever you are recessed from the courtroom for lunch, a break, or overnight, you are not allowed to discuss the case with anyone, including your family, friends, and fellow jurors. During your service as a juror in trial, avoid newspapers, television, and news programming that could include a story about the trial in which you are sitting as a juror. Do not do any independent research on the case. You are only allowed to consider the facts as presented to you in the courtroom. Follow rules and avoid media, internet, and social media. If anyone tries to discuss the case with you, notify the judge or clerk immediately. Fairness requires following the rules.
This was really strange for me because I usually go home and talk to my husband about my day, and not being able to do that was just really weird.
After both sides have finished presenting their evidence, the judge will instruct the jury. The judge's instructions are the law of the case, and you must follow them during your deliberations. These instructions are legal standards that the jury will use to decide the verdict. Jurors must follow the law as instructed by the judge, even if the jurors may have an idea of what the law is or ought to be. After the judge's instructions are provided, deliberations begin, which is the first opportunity for jurors to discuss the case with one another. After the instructions are given, each side will present closing arguments. Closing arguments sum up each side's case and give the reasons why the jury should decide in favor of that side. Like opening statements, the closing arguments are not to be considered as evidence. After the closing arguments, the jury will begin deliberation in the jury room. In the jury room, the jurors should first elect a foreperson to lead the deliberation. That person is responsible for maintaining order during deliberations.
So I think first we should probably figure out who the foreperson is going to be. Any volunteers or?
I've been a foreperson before, so I don't mind.
Is everyone good with that?
Yes.
Okay.
At this point, the case is in the jury's hands for decision. If you have a question, the foreperson should write it down and give it to the bailiff, who will take it to the judge.
I believed the witness. I thought that she was really credible.
Yeah, this is really hard. I thought everybody brought up some good points.
During deliberations, speak freely and keep an open mind. Listen to the opinions and points of view of the other jurors, but make your own decision. Do not be intimidated by opinions, and remember, opinions and minds can change. Were the witnesses credible? Was the evidence convincing? After a full discussion of the issues, you will each need to state your decision. If you don't agree with your fellow jurors, you may continue to discuss the case. If there is no agreement, the result will be a mistrial. In both criminal and civil cases, a jury's decision must be unanimous. A civil case generally must be proven by the greater weight of the evidence. In contrast, a criminal case must be proven beyond a reasonable doubt. When the jury has reached its unanimous verdict, the foreperson must sign the verdict form and notify the bailiff. The bailiff will alert the judge, and all parties will be summoned back to court. After the verdict is announced,
we, the jury, find in favor for the defendant. Signed, foreperson.
Your Honor, I would make a request to poll the jury.
the lawyers may ask the judge to question the jurors individually to confirm that the verdict is accurate. This is called polling the jury. The judge will then dismiss the jury, and you will be free to leave and to discuss the case with anyone. We hope that this video has answered most, if not all, of your questions about service and responsibilities. If you have any further questions, please do not hesitate to ask any of our staff here today.